The Spending Clause, Common Interpretation by Samuel R. Barjenstos and Jan Solmin. The Spending Clause gives Congress the power to lay and collect taxes, duties, imposts, and exercises to pay the debts and provide for the common defense and the general welfare of the United States. Beginning in the 1790s, there has been a long-standing debate over the scope of the spending power and the meaning of general welfare. James Madison and the other Democrat Republicans argued that the clause authorizes spending only when it implements other powers granted to Congress in Article 1 of the Constitution. Alexander Hamilton and the Federalists took a broader view. Hamilton famously argued that the clause authorized spending so long as the object to which an appropriation of money is to be made must be general and not local. Its operation extending in fact or by possibility throughout the Union, and not being confined to a particular spot. While Hamilton did not advocate a completely unbounded interpretation of general welfare, under which Congress could spend money for virtually any object it considered beneficial, he and the Federalists did believe that the clause authorized a wide range of spending for purposes that go beyond Congress's other enumerated powers, so long as they were sufficiently general. The debate between the Madisonian and the Hamiltonian views continued throughout much of the 19th and early 20th century, as the general Democratic presidents and the members of Congress tended to adopt positions similar to Madison's, or slightly broader. Thomas Jefferson, Madison, James Monroe, James Polk, James Buchanan, and Grover Cleveland all opposed bills authorizing spending on local infrastructure and disaster relief projects, citing constitutional objections. By contrast, the Federalists, the Whigs, and the Republicans tend to take a broader view of congressional power, closer to Hamilton's position. Whig leader Henry Clay, for example, argued that the clause authorized his proposal for a wide-ranging American system of canal and road building. My own notes that it happened, I think, in Lincoln's time when he was trying to be elected in the Congress, I believe. A state legislature, I believe. Sorry. For most of this time, federal grants to state governments were relatively rare, and only a small portion of state finances. The grants that were enacted were mostly, though not entirely, for purposes that would be readily defended even on Madisonian grounds, such as national defense and relief of state debts incurred in the Revolutionary War. Federal grants to state governments became more important in the 20th century, and the constitutional controversies over them became more significant because, especially when it comes to conditional grants, which require states to comply with federal dictates of various kinds in order to qualify for their share of the funds. States today rely heavily on federal spending to provide public services. Federal funds account for just under a third of average state's budget. The more conditions Congress can place on the recipient of federal funds, the more control Congress can exercise over the operation of state governments. In the two 1923 cases, Massachusetts vs. Mellon and Frothingham vs. Mellon, the Supreme Court sharply limited the ability of state governments and individual citizens to challenge such grants. The court ruled that the challengers lacked standing unless the spending conditions inflicted some direct injury suffered or threatened. Applied expensively, this principle might make it almost impossible for either states or individual citizens to challenge most conditional spending programs. However, the court has allowed challenges to some conditional programs in cases where states and individuals demonstrated sufficient potential injury to satisfy the justices. The court's first case on the scope for the spending clause came in 1936. United States versus Butler, 1936. The court invalidated the first Agricultural Adjustment Act, AAA, a statute that paid farmers to reduce the crop production. The court expressively took Hamilton's side of the debate with Madison. It declared the power of Congress to authorize expenditure of public monies for public purposes is not limited by the direct grants of legislative power found in the Constitution. Nevertheless, the court held the AAA unconstitutional on the ground that the act invades the reserved rights of the states. Under the Commerce Clause doctrine at the time, evidence in cases like United States versus EC9 Corporation, 1895, Congress lacked the power to reduce agricultural production directly. The court concluded that Congress could not pay farmers to achieve the same ends indirectly, although the Butler court said it was adopting the Hamiltonian position. A strong case can be made that its decision was more consistent with the logic of the Madisonian position. Since Butler, the court has repeatedly endorsed Hamilton's position and has arguably gone beyond Hamilton in broadly deferring to Congress' determination of what expenditure serves the general welfare, as in South Dakota versus Dole, 1987. Butler's invalidation of the AAA, by contrast, is now an outliner. The judiciary focus had turned to invalidating the conditions federal spending statutes placed on state governments. The court has invoked three possible constraints on federal grants, which with mixed results. First, the court had required that the federal government make its condition clear at the time the states accept the grants. Arlington Central School District versus Murphy, 2006. This rule makes it harder to impose grant conditions by requiring precise drafting, but it does not actually stop Congress from imposing any condition it wants, so long as they are clear enough. The court has in a few cases ruled against the federal government in grant cases because the condition in question wasn't sufficiently clear. Second, the court said that a condition might be unconstitutional if it was too loosely related to the purpose of a grant to which it was attached. But grant's purpose can typically be described broadly enough to ensure that the relatedness doctrine imposes a few meaningful limitations. In South Dakota versus Dole, for example, the court upheld the law conditional receipt of federal highway funds on states raising their drinking ages to 21 because both the funding and the condition promoted safe interstate travel. Third, the court indicated that Congress' financial inducement might sometimes be unconstitutional coercive. But the court never actually ruled that a condition coerced states until its 2012 decision addressing the Affordable Care Act, ACA, FIB versus Sebelius. One provision of the ACA requires states that participate in Medicaid to expand the Medicaid program to all adults with incomes up to 133% of the federal poverty level. In a ruling endorsed by 7 of 9 justices, the court held that the threatening loss of all Medicaid funds to states that refuse to expand the program renders the offer unconstitutionally coercive. Chief Justice Roberts' pivotal opinion pointed to 3 aspects of Medicaid expansion he found crucial. First, extremely large amount of money was at stake, making the threat a gun to the head of states. Federal Medicaid funding accounts for some 10 to 20% of the average state's revenues. Second, the expansion transformed Medicaid from the provision for health care for particular categories of needy people, the elderly or those with disabilities or with their children, to a universal guarantee of health care for relatively poor. Third, States could not have anticipated when they entered Medicaid many years ago that Congress would later condition continued participation in that program on entry into the dramatically transformed program created by the ACA. NFIB is still the only time that a majority of the courts has invalidated the spending condition because it coerces states. It remains unclear what, if any, other states might approve coercive on the Chief Justice's analysis, which blended concerns about the uniquely large stakes with respect to the notice and relatedness requirements. But the court decision does show that there remain some judicial enforceable limits on the constitutional spending power. Matters of debate. The first opinion is for broad spending power by Samuel R. Bojangles. The New Deal of great societies and the marketplace on the shape of American government would not have been possible without the spending clause. The Social Security Act and all its component programs, old age survivors and disability insurance, unemployment insurance, and the old age to families with dependent children program, and the successor temporary assistance for needy families, Medicare, Medicaid, and the children's health insurance program, and more, all found their source of constitutional authority in the spending clause. So too with the key federal education programs such as the Elementary and the Secondary Education Acts, which offers aid to states to provide to their schools, and the Higher Education Act, which, among other things, supports financial aid for college students. A Individuals with Disability Education Act, which guarantees education to children with disabilities. Federal housing and employment program also rests on the spending clause, as do the vast federal investment in our transportation infrastructure that took off when President Eisenhower signed a Federal Aid Highway Act in 1956. And some of the most far-reaching and important civil rights statutes, Title VI of the Civil Rights Act of 1964, which prohibits race discrimination, Title IX of the Education Amendments 1972, which prohibits sex discrimination education, and Section 504 of the Rehabilitation Act of 1973, which prohibits disability discrimination, were adopted under Congress spending power as well. Despite the efforts of some influential academics and lawyers for states who have brought litigation based on those academic theories, the Supreme Court done very little to limit Congress exercises of power to attach conditions to federal funding to fund federal funds under the spending clause. Even the 1912 NFIB versus Spilius decision, which represents the one time the court has invalidated the federal spending condition as coercive, involved such an extreme statute that it is unlikely to impose much of a limitation on Congress's power. One's attitude about the failure of the court to impose more meaningful limits might well depend on how one feels about the vast expansion of the American federal government since the 1930s. It is no surprise that those who, like me, are largely comfortable with the court's jurisprudence that are also generally supportive of the change that the New Deal and the Great Society made to the shape of the American government. Nor is it a surprise that those who seek more judicial imposed limits on the spending power are skeptical of the New Deal and the Great Society. I believe that the court has acted sensibly in refusing to place more significant limits on Congress' use of spending power. There are two reasons for this conclusion. First, since the New Deal, our constitutional system has settled on the position that it is for Congress, not the courts, to determine what is in the public interest. If the Supreme Court was to reject the spending laws on the ground that those laws did not fit the court's understanding of the general welfare, it would subvert an important protection of democratic decision-making. Second, conditional federal spending affirmatively advances the goals of dual federalism. There are many policies that the people in most, if not all states, would prefer to implement, but that collective action dynamic keep any individual state from implementing on its own. That is a point Justice Cardozo made in the Stewart Machine Corporation versus Davis 1937 case that upheld the federal unemployment insurance program under the spending clause. Many states wanted to adopt unemployment insurance systems, but they feared that if they imposed the taxes not necessary to pay for such systems, they would place themselves in a position of economic disadvantage as compared with the neighbors or competitors. A federal program that gave all states an incentive to participate or overcome that collect action dynamic and facilitated adoption of a policy that was welcomed in all corners of the nation. The original Medicaid program, in which the federal government offers states money to provide health insurance for poor people, helped to overcome a similar dynamic. Would it be perfectly possible for the federal government simply to bypass the states and provide services such like this itself, but providing the services through the mechanism for conditional grants serves important purposes? By giving states key responsibility for implementing federal policies, conditional spending helps to ensure that a program will be administered by officials who are geographically closer and more politically responsive to local concerns than officials in the nation's capital. States can mold aspects of their implementation to adapt to the unique local conditions or experiment with new administrative approaches, and the state officials can seek in recent years have often obtained waivers of federal program rules to do so. Critics conditional spending worry that Congress will use the spending clause to bypass limitation on its power to regulate under the Commerce Clause, the Reconstruction Amendments and other constitutional provisions, but the conditional spending power contained its own built-in limit. Congress cannot enlist the state participation unless it is willing to pay what the state demands. Given the realities of modern federal budget politics, that built-in limits give states key leverage in negotiating the terms of state-federal cooperative programs. The states have proved remarkably sophisticated using that leverage. Take a salient recent example. Under the ACA's Medicaid expansion, Congress agreed that the federal government would pay 100% of states' costs initially, dropping to 90% after a few years. An extraordinary generous offer for the program that provides important services to state residents. When the federal program relies on the conditional spending power, then it is especially likely to take a form that is respectful of state interests. The spending clause serves important purposes in our federal system, and Congress has used its power under that clause to address significant public interests. The Supreme Court has been correct in giving Congress a wide berth to do so. Now the next perspective is putting the general back in the General Welfare Clause by Ian Solomon. The spending clause authorizes Congress to raise taxes, spending money to pay the debts provided for the common defense and general welfare of the United States. These words cannot possibly justify the modern doctrine that the term general welfare authorizes Congress to spend money for virtually any purpose it wants. If, as the Supreme Court has held since 1930, the General Welfare Clause gives Congress the power to spend for almost any purpose it considers beneficial, there would have been no need to give it its authority to spend for the common defense or to pay federal debts. Both purposes are obviously beneficial to the nation, and both are rendered superfluous by the modern interpretation of general welfare. The modern approach runs counter to the original meaning of the Constitution as well as the text. It makes a mockery of the Federalists' repeated assurance that the Constitution sets strict limits on federal power, including the power to spend. In the Federalist number 41, for example, James Madison emphasized that the phrase general welfare was limited by the enumeration of other powers of Congress. It did not give it the power to legislate in all cases whatsoever. Even Alexander Hamilton's broad construction of the clause, which held that it authorized spending for all objects that are general and not local, and not being confined to a particular spot, fell well short of the modern approach. grants to specific state and local governments are almost by definition confined to a particular spot. In any event, however, Hamilton's theory is itself flawed because it too tends to make the power to spend for defense and debt payments redundant, especially the latter. Such spending is almost always general in his sense of the term. Defenders of the modern approach to the spending power usually focus on pragmatic living constitution considerations rather than text and original meaning. They claim that a virtually unlimited spending power is necessary for effective policy making in the modern world, even if we assume that it is proper for courts to consider such policy considerations. They are dubious on their own terms. Unconstrained federal spending since the 1930s has caused considerable harm. Federal subsidy for local pork barrel projects that is notorious bridge nowhere have wasted resources skewed public work priorities. Federal grants to state governments and interest groups have often created and enforced cartels that harm consumers, especially the poor. For example, the Agriculture Adjustment Acts 1935 and 1938, which led to Supreme Court decision vastly spending skilled congressional power, paid farmers to artificially reduce production. This increased the price of food during the Great Depression, at a time when millions of Americans were already having great difficulty making ends meet, or even suffering from malnutrition. Federal farm subsidies associated with production restrictions continue to inflate the price of food to this day. Disproportionately harming the poor in the process. The growth of mass entitlement programs poses a severe threat to our facial feature, often subsidizing the relatively affluent at the expense of the relatively poor. Advocates of unconstrained spending power contend that it is necessary to prevent collective action problems among the states, enable them to cooperate in situations where they would otherwise find it impossible. But such power also routinely creates dangerous collective action problems benefiting powerful special interests at the expense of a less well-organized general public. Individual states acting on their own could never have established nationwide agricultural cartels that fleece consumers, where genuine interstate collective action problems exist. They can usually be addressed without giving Congress a blank check to spend for whatever purpose it wants. The widespread use of federal grants to state governments undermines the beneficial diversity competition between state and local governments, which also helps the poor and the oppressed. States and localities can rely on the federal government for funds, have less incentive to innovate, and adopt policy attractive to people voting with their fate. In a nation as large, diverse, and complex as the modern United States, federally imposing standardization policy facilitated by conditional spending grants is often harmful. Indeed, this is more true today than at the time of the founding, when the nation was smaller and less diverse, the government policy much simpler. In this respect, a pragmatic living constitution approach to constitutional interpretation argues for tightening constitutional limits on federal power rather than loosening them. In some instances, states have refused to accept EU conditional spending grants, but the vast majority of the time, states' government found it hard to resist the temptation of federal funds, especially if they were being taxed to provide similar grants to other states that compete with them. In many cases, widespread voter ignorance makes it hard for the electorate to monitor these complex programs. Even most originalists recognize that the Supreme Court can or should not strike down all federal programs that go beyond the text or the original meaning of the spending clause. Some, most notably Social Security and Medicare, are too well entrenched to be reversed by judicial action alone. Moreover, it would be unjust to suddenly pull the rug out from under the many people who rely on them. But the court can still take incremental steps in the direction of enforcing constitutional limits on federal power. For example, it can hold new unconstitutional programs to a higher level of scrutiny than existing well-established ones on which many people rely. Such a distinction is already implicit in the court's ruling in NFIB versus Sebelius, 1912, where the justices invalidated a key part of the Affordable Care Act, in part because it was a massive step beyond the existing Medicaid program. It can also strike down on the list some of the many blatant cases of spending interest spending that go beyond even the Hamiltonian position. Enforcement of the tighter conception of general welfare is not only practical, it is easier for judges to do. The administration of the court's current approach to federal grants to state governments, which requires extraordinarily difficult determinations about whether a particular grant condition is coercive or insufficiently clear. Unlike coercion, the phrase general welfare is actually in the Constitution and can be analyzed using conventional method of legal interpretation. From the standpoint of both originalism and the pragmatic living constitutionalism, the core spending clause jurisprudence is badly flawed. Fortunately, perpetuation of the status quo and complete judicial reversal of the modern approach are not the only two options available. We can and must get beyond this false choice.